Okay, guys, so we'll start with the session. Before starting with the session, I'll just give a brief introduction about the speaker. So, today's session is going to be taken by Senior Advocate Shashi Kiran. She has represented top organizations such as Delhi Metro, MTNL, HAL, MCD, the Union of India, and the Ministry of Railways. She is widely recognized for her impactful contributions to public interest litigation and has authored several notable works, including Digest on Land Laws, Law of Maintenance, and Professional Ethics. So, without further ado, we will just start with this session. I will hand over the mic to Advocate Shashi ma'am. And ma'am, you can start with the session.
Good evening, everybody. Today we are presenting this lecture. I'm present on the public interest litigation. Public interest litigation is the voice of the voiceless and a bridge to social justice. Dhananjay, have you got my PPT?
Ma'am, you can share directly as well because we haven't received it yet.
No, we have. I've already sent it. Just check up.
Yes, ma'am, sure.
Just check up for a moment.
Yeah.
Otherwise, I will start as it is. No issue.
Ma'am, we haven't received it. You can directly screen share as well.
Okay, anyhow. Just a minute.
You can share me on the WhatsApp.
Just a minute.
Yes, ma'am, received.
Yeah. You received? Have you received?
Yes.
Okay, just you can then put it. Have you got it?
Ma'am, the PPT is live.
Yeah, okay. So, fine. Just a minute. Yes, we will start it now. Good evening to everybody. Yeah, today we are discussing public interest litigation, and I'm delivering this lecture on the public interest litigation. Public interest litigation is a litigation which is for the public. One may have grievances or not, it is immaterial. It is called public interest litigation because it is for the welfare of the public. So that is the reason we call it a public interest litigation. And this is public interest litigation is the voice of the voiceless and a bridge to social justice. So we can say PIL litigation for the protection of public interest. Anyone can file, not limited by locus standi. You know what is locus standi? Locus standi is a person who is having cause to file a case. But here, in the cases of public interest litigation, one may have cause or not, but he can file it for the public, for larger interest, in larger interest for the public, for anyone. This is based on Article 32 and 226. its objective is to make justice accessible to people who are not able to come to the court, who are in marginalized, who are on the margin of the society, who are not able to fight their own cases. Such people can not people such people cannot come to court, they cannot approach, therefore anybody can approach on their behalf. So this is the public interest litigation. Pre 1970 it was strictly locus standi. In any case, if anybody was having grievances, only that person should have come to court. This was the opinion of the court. They refused to entertain people if they are not having any grievances. Means if anybody who is not having grievances cannot approach the court. This was the situation till 1970. But thereafter, in 1979, Husainara Khatun is a case which was which came to Supreme Court. How it came, I will tell you. This is a PIL filed based on newspaper reports exposing the inhuman conditions of under trial prisoners in Bihar. So this way, a PIL was filed, and then this started. This is a start of new public interest litigation. Court treated this letter as a writ petition and ordered the release of numbers of prisoners who were in detention who have already exceeded the maximum sentence. There were many prisoners who, suppose they would have got sentenced for 10 years, but beyond 10 years, they were in the jail. So this litigation, this Husainara Khatun, this was a letter written to the Supreme Court. In this matter, they ordered that no, prisoners should be released from the jail. So this was a case. Now next is in 1981. 1981 SP Gupta. This is a very important case. It is also known as first judge's case also. This case, I will just tell you in brief because there is a lot of things which I have to tell. So in case you want to study anything more, I am giving you all the details and year of the case. You can study these cases separately also. But I will just tell you that this case, SP Gupta case, this is a case which is known as first judge's case. And in this case, this happened. A senior advocate wrote a letter to the Supreme Court and they have highlighted some grievances of the judges. So initially they said, no, these are the grievances of judges. Why you are coming? Why you are approaching the court? This is a very landmark judgment in the history of the public interest litigation in India. While often recommended as first judge's case for its impact on judicial appointments, its significance for PIL lies in its expensive interpretation of the concept of the locus standi. This is the case where court said no. Even persons who are able to approach court, but if in larger interest somebody else approaches on their behalf, even then they can treat it as PIL and they can entertain this. So this is a very important case. Now next is another. I will tell you, Justice P.N. Bhagwati. You know Justice P.N. Bhagwati. He has been in the Supreme Court. He was a judge of the Supreme Court, Chief Justice of India also. And Justice Bhagwati has introduced even postcard was treated as writ petition. So he has treated many such letters as writ petition, and then necessary orders were passed. So now I will tell you. Next is human rights. I will tell you how PIL has been developing. It was developing day by day. Every time new cases were coming with new subject. So same way, this Sila Barse, this is also one of the case, and where some of the women who were in custodial police custody or in the police lockup, they were not treating well. So custodial violence and abuse against women was the cause for filing this PIL. This was also in the form of a letter which was written to the court, and then court treated it as a PIL, they treated that letter as a writ petition, and then this order was passed. So they may get relief. Another case is of Sunil Batra. Sunil Batra, he was also in Tihar jail, Delhi, and he wrote a letter to the Supreme Court, and in letter he has explained how there has been brutal torture to the fellow prisoners. So then court said no. Even if people who are in prison, who are in jail, they cannot be treated so badly. There cannot be torture to them. So they condemn inhuman treatment to prisoners, and then this is an important case. Now another case is of MC Mehta. There are series of cases of MC Mehta. All the cases, most of them are on environment. So MC Mehta has filed many cases, numerous PI public interest litigation, which resulted in landmark environmental protection judgments. So various cases are there: environment protection on the hill area, environment protection of from the pollution. There are many series of cases you will find. Now, another important case is on public interest litigation is women and child rights. That is Vishakha. Vishakha case, I think you must be knowing. This is a very important case. And Vishakha case is a case where there was a sexual harassment to a woman. And then a PIL was filed and law was made. This is also known as Vishakha guidelines. Subsequently, there was law, that is protection of women from sexual harassment at workplace. That act was enacted after the judgment which came in this Vishakha case, Vishakha versus State of Rajasthan. This is of 1997. So in this case, it happened that at workplace, a woman was gang raped, and then social worker, she was a social worker, and then PIL was filed, and guidelines were sought from the Supreme Court that there should be some protection of women at the workplace, and thereafter these guidelines are called as Vishakha guidelines, on which subsequently this act was passed, Sexual Harassment of Women at Workplace Act. This act was passed in 2013, whereas this Vishakha guideline case came in 1997. Now I will tell you about few more cases. Another case is Lakshmi versus Union of India. This is also important case because this is related to acid attack survivor Lakshmi Agrawal, who filed a PIL, leading to and sought various relief for the regarding sale of acid. Thereafter, Supreme Court issued some guidelines, and they said no, whosoever is purchasing the acid, their identity should be known, and it should be noted how they are purchasing and for what purpose they are purchasing. So all these things are there. Now another thing is this. Next case is Vineet Narayan. This Vineet Narayan case, it is also known as Jain Hawala case. This PL was filed by the journalist Vineet Narayan after the Central Bureau of Investigation failed to investigate a high-profile corruption scandal involving senior officers. So this was very important case as far as this PIL is concerned, and especially high-profile people were there who were, nobody was taking action against them. So therefore, this is a case which is very important, filed by the journalist. Now next is Olga Tallis case. Olga Tallis is also case related to pavement dwellers in Mumbai. So they were being evicted without notice. Then this was the case which was filed in the Supreme Court under Article 21, saying that they should be protected. Right to livelihood is involved in. This was the plea in this case. And then Supreme Court intervened, and they said you cannot throw, they may be pavement dwellers in different places, but you cannot evict them without any just and fair procedure. So this is also important case. Now another case is Bandhuwa Mukti Morcha. This Bandhuwa Mukti Morcha is a case which arose from a letter reporting the horrified conditions of the bonded laborers in stone quarries. This is the case where, again, Justice Bhagwati treated a letter as a writ petition and ordered an investigation in the matter. Then court issued certain guidelines and then identifying and releasing and rehabilitating the bonded labor was done. So this is also very important. Now I will just give you a sketch about landmark PIL cases. As you can see, this is there are various cases as it is there. Right to speedy trial. I already explained you Husainara Khatun case, SP Gupta, that is judge's case. In this case, expanded of locus standi was there. Bandhuwa Mukti Morcha, bonded labor rights case. Olga Tallis, right to livelihood. MC Mehta, environment protection. Vishakha, gender justice case. Vineet Narayan, CBI independence related to corruption and other things. Balwant Singh, Chopal. This is another case where guidelines were given to prevent misuse. So these are the cases which I have just given you at a glance, that these are the important cases. Now we will just proceed further. Yes. Now advantage of PIL. You have seen, so there are so many cases have been filed. Now, what are the advantages of PIL? You know, suppose these cases would not have been filed, then certainly these cases, there would have been no protection of these people who have got relief after filing the PIL. So same way, there has been, access to justice for poor and voiceless people in judicial innovation. So these are the cases. So this is the advantage of the PIL, that voiceless people are getting their voice. Their voice has been before the Supreme Court through letter, through filing PIL. So this is another judicial innovation under Article 21. Accountability of public authorities, crystals for social, economic, and environmental laws. So these are the things how PIL has been beneficial for all of us, for the public at large. Even promotes public awareness. So all these are the things which, there has been approaching people have been coming to Supreme Court and they are filing such petition. Are sometimes Supreme Court is treating writ petition. Even a letter has been treated writ petition. So this has been advantage. People approach the court without any, you can say, spending money, and their voice is heard by the Supreme Court. So this is the advantage of PIL. And now we will see misuse and limitations. What are the limitations of PIL? And what are the misuse? Sometimes people file PIL just to set their own personal grievances on they can raise. There are some people, as I remember, in one of the case, somebody approached High Court in the name of PIL, and they said so many people are encroaching the land. Whereas when it was found out, data was called, then it was not encroachment. This was called just by that person to settle personal conflicts with the persons who were his neighbors, and he wanted to just tell them, give a lesson to them, I can raise some voice in the court and then there may be some relief to that person. So sometimes people file, frivolous petitions also, frivolous PIL also. So certainly this is not a good step. And now, sometime, even if there is a genuine case and PIL is filed, so there may be delay because PIL also takes a lot of time. So if it is not a genuine case, It delay the process of law. Court valuable time is wasted in PIL. But certainly, it's not every time. So, and court is there to look into it whether PIL is genuine or not. So, lack of petitioners' accountability is maybe there sometime, and they can file such petitions which are not relevant or which are just filed to settle their personal score. So these are the disadvantages also. There are the limitations also. And in one of the matter also, Supreme Court has discussed about accountability of the petitioner, lack of petitioner's accountability in Subhash Kumar versus State of Bihar. Now, next is Supreme Court guidelines. You know, in time to time, Supreme Court has given certain guidelines. One should file PIL and when one should file and who are the persons who cannot file. So Supreme Court has given guidelines in various cases. I have just mentioned one or two cases. Balwant Singh, Chofal, Janta Dal, and then Kalyaneshwari versus Union of India. These are the cases where Supreme Court has given certain guidelines, where Supreme Court says no, when one should file the PIL and who should not file. This is also there. So certain guidelines are there. Now I will tell you about some recent landmark PIL judgment. You know, there are various judgments in Supreme Court. As you know, some of the judgment are there which have been, discussed and recently, because these are recently, I think 2024 and 25 judgment. So you can just see that how these judgments have been very important. Right to be free from climate change impact. This is on this issue, there is a case MK Ranjit Singh versus Union of India. Then Jeff Foundation versus Union of India. This is also PIL on social media used by children. Then digital access as a fundamental right. So here also equitable internet access under Article 21. Then electoral bond challenge, transparency in political funding. So these are some of the cases where Supreme Court has discussed various issues. So in same way, I will just tell you what are the other judgments. I think instead of telling judgment, I should wrap up about discussion. Then if anybody has any question, then can ask. But I will just give you some uh, points for discussion. Now this is for you to discuss whether PIL become judicial activism or social necessity. Think about it. We can discuss on this issue. And then should PIL address policy matters or strictly legal rights? What court should do, whether court should deal with all type of policy matters also in PIL, or only should restrict to legal rights or fundamental right of citizens. So this is also one of the issue which needs deliberation. Then further, which judgment best represents the spirit of PIL today? So this is also to be discussed. We can discuss this also. Then what public cause would you choose for a model PIL? Now, suppose you have to file a PIL. Then you think about it, what subject you should choose for a modern PIL. You think about it and then you can tell me that what is your idea. What if you have to file a PIL, you will file for what cause? Think about it and then we will discuss. Now, my conclusion is this: PIL transformed the court from a court of law into a court of justice. Cornerstone of social justice and constitutional transformation requires responsibility and genuine intent. So, this is in all that about the PIL. Now, I think you can ask some questions in case you have anything in your mind. Then I can explain you further. Yes, any questions, please?
Guys, if you have any questions, you can directly turn on your mic and ask those questions, or you can drop the questions in the chat as well. So you can start with the questions. Sagar has raised his hand. Yes, Sagar. Sagar, you can ask your question.
Yes, Sagar, I cannot hear you.
Anyone has any questions? We are open for Q&A session as of now. You can directly turn on your mic and ask the questions. No one has any questions?
I have given you some clue that you can discuss about all this thing. Anybody can tell me, in case you have to file a PIL, on what subject, on what topic you will file PIL? Anybody? You can just think about it. If in case you feel that yes, there is a violation of some fundamental right, or there is some other deficiency in our system, whether can you think that you can file a PIL?
We have one question from Dibyendu, and his question is: what safeguards should exist to prevent the misuse of PILs while still encouraging citizen participation in justice?
I just repeat the question again.
What safeguards should exist to prevent the misuse of PILs while still encouraging citizen participation in justice?
Yes, you see, right now when PIL is filed, then court looks into various aspects. Court just see that whether person who is filing a PIL is a genuine or not. He may not be having locus standi, that is not the point, but for what reason he is approaching and what research he has done, whether he has approached the ministry concerned before filing the PIL. So all these are the uh, court queries, and court look into all these things. They look whether person has approached the authority. Suppose you want to file a PIL that there is some people are there who are not being uh, re- not being taken proper care in certain hospital or some place, maybe any public place, you can say, or maybe child home. court will ask Court will ask that whether you have approached the concerned authority. If you have not approached, court will say no, your PIL is not maintainable. Even Supreme Court registry will say no, first you show us whether you have approached the government, whether you approached the concerned ministry. So then only they will entertain your PIL. So they will not entertain if you have not approached them. Court wants that first you should go to the concerned ministry, you should go to concerned authority, and then you should tell them what are your grievances. And in case they don't give any reply, then you can come to Supreme Court. So now, is it okay? It's clear to you? And beside this, there has been guidelines of Supreme Court, and not even Supreme Court, different high courts have different guidelines to file PIL. They can, without following those guidelines, no one can file PIL. So in those guidelines, it is clearly mentioned that in case petition is frivolous petition, and if it is not for public interest, court may impose cost also. So these are the things which one should know before filing PIL.
Okay, we have one question from Sagar as well. Is
Yes.
there any specified time limit for file the PIL?
No, there is no specific time limit, but of course, there should be a cause of action. And suppose cause of action is there, then you can file at any point of time. Suppose no one has filed and still it is some grievances are there, then certainly you can file even at later stage. As I will just give you one example. there was sometime, I think maybe 2 3 decades before, there was lot of people, rather I will say nursing home, who were doing sex determination test, and they used to tell to the couple that whether unborn child is a female or male. And sometime many couples, they used to abort a child in case it's not of their choice, or maybe if it is that child fetus is female. So what happened? Then a petition was filed by the Chetna Welfare Society, NGO, that sex determination tests should be banned. And certainly thereafter, government has taken action and they made a law. Now at present, nobody can disclose the sex of the child, of unborn child. So this is the situation. So it was, practice was going on. Nobody filed any petition. But one point of time, if a petition is filed, then court will not say it is being done since long for many years. Why we should interfere now? No, there is no such time limit. One can approach any time. कहते हैं ना जब जागो तभी सवेरा. The same way.
Okay, we have one question from Vaishnavi. Her question is, ma'am, can we also file a PIL in district court?
No, not. Only in Supreme Court and High Court. District Court has no powers. As you know, in Supreme Court under Article 32, PIL can be filed, and in High Court under 226. But District Court has no such powers. So in District Court, PIL cannot be filed.
Ma'am, there is one more question.
Yes, yes.
As you said, we have to approach directly to the ministry, and
Yes.
then we can only go to the Supreme Court. Like
Yes.
if I have a problem regarding some kind of right in the hospital, so is it, are you referring ministry as in I should go to the authority of the hospital or the courts which are present there?
You see, a procedure is this. Suppose you are having grievances against a particular hospital, then you should approach the hospital management. Suppose they also don't look into it, then you should approach the health minister. Health ministry you should approach. Even if they don't do anything, then you can approach to Supreme Court. But suppose there are such grievances that you have no time to approach anybody, as it happened sometime, court suo motu also take notice of certain things. So court can also take some notice in case there is something very urgent nature, and if there is a matter of human violation of human rights, then court can also suo motu issue notice, as court has done in the Calcutta rape case. They have issued suo motu notice. So this can also be done, but otherwise one can approach the concerned authority, concerned ministry. Then if they don't do anything, then can approach the court.
Okay, ma'am, got it. Thank you.
Yes, anybody?
Anyone else has any questions? If anyone else has any questions, they can just ask it.
Yes, I have a question.
Yes.
Yes.
Shailendra, you are not audible. There is some
saying certain rights are violated, and do we need to see any legal provisions are available against that particular harassment or that particular non-compliance? And then only we should go to, if it is not there in the legal system, then we should approach High Court for the PIL.
No,
is that the step in between, or we can directly go to?
I think no. I will tell you. You want to say what I have understood, that you want to know whether you should go to High Court or Supreme Court. What is your question?
No, sorry. In between, my voice might have got lost. I will again repeat. Before approaching High Court or Supreme Court under Article 26 and 226, 32 and 226, am I supposed to approach district court or civil court any for the legal provisions available against that non-compliance first?
You see, normally for public interest litigation, when we file a case, when we file for the public at large, suppose something has happened in your house Suppose your neighbor has done some serious problem is there, seepage problem is there, or some water is coming in your basement or maybe in your floor. You can't file a PIL for this. For this, you have to go to district court and you will file injunction suit for relief. But suppose something happens and this is for the larger people. Suppose something is there that the whole, um, all the people are doing some work which are, against the public at large. Just for example, there were so many basement where water used to come inside during rainy season, and this was not fault of those persons. This was fault of municipal corporation, that they have not done the sewerage system. Their sewerage system is not proper. Certainly, then one can file public interest litigation that in this locality, whenever there is a rain, water comes inside the house, in all the houses, and this is the problem we are facing since long. Then you can write this to the authorities, and if authorities are not doing anything, then you can approach through PIL, maybe in the concerned High Court, and if not, then certainly in Supreme Court. So this is the issue, how you should go about it. But it is not that you should go to district court first and then you should go to High Court or Supreme Court. No, you don't have to go for violation of fundamental right or for filing writ. You don't go to district court. You have to come to High Court or Supreme Court. So that is the thing. So in case there is any grievances, anybody wants that no, one should file the petition, then certainly can file in High Court or Supreme Court, not in district court.
So, ma'am, one cannot file the PIL against the individual. So it have to be the group of people or the government like we are against, like filing the PIL.
You see, sometime it may be against individual also, but normally it is not against individual. As I will tell you, in one of the case, some tannery in Kanpur was throwing water, wastewater, in Ganga river. It came in the notice of the some person, and they filed a case as a PIL. Later on, when they were filing, they came to know. Then they made inquiries. They came to know many people are doing like this. So even if one person is doing, it can be filed. But even if many people are doing, even then it can be filed. So it depends on the nature of cause, whether cause is such that it is affecting by one person and one person is sufficient if we want to file a public interest litigation. Sometimes there may be many people, then also it can be filed. So it depends on the nature of cause. It can be filed.
Okay, ma'am. Thank you.
We have a question from KK. How to file a PIL? Is it costly affair?
It is not so costly. There are 2-3 reasons I will explain you. Suppose a person wants to file PIL through advocate, then certainly it depends on the advocate. Advocate may charge professional fee, but many advocates, they don't charge much in public interest litigation. They love to do PIL, even if don't get much fee as per whatever is their schedule fee. Even if they don't get, even then they do it PIL. Even I have done many PIL where I have not charged anything, but there should be. I only take such cases where there is, which I personally feel are genuine one. I will tell you, recently, in this year only, we filed one PIL on behalf of an organization, Jan Shruti, that's People Voice. That organization approached me and they said, nowadays there are a lot of litigation and many people, especially men, are suffering. Why? Because court is granting maintenance, even if there is a marriage of 1 month, 2 months, 3 months, 4 months, or maybe 1 year, 2 year, or maybe 10 years. When wife approaches the court grant maintenance without looking into the provision of 125 CRPC, which clearly mention in case woman is not able to earn not capable to earn, then only maintenance should be granted. But court don't look all these aspects and they just award maintenance. And it happened in many cases. Court, when people used to approach Supreme Court just looking into the individual case, no, 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 no. Maintenance has been given. No, no, you keep on paying, keep on paying. They don't, give any proper direction. They don't look into this aspect. Since how long woman is getting maintenance, and woman is getting continuously. I've seen in a cases where whole life woman is getting maintenance. I've seen cases where woman is getting maintenance since last 14, 15 years. So it was happening. And this NGO, Jan Shruti, they handed over the case and they said, no, we want that you should argue this case. I argued, no doubt, court has not given any judgment in favor. But court said we will look into such cases in appropriate matters. And they have given a long order why they are not considering, why they don't want to interfere in such matters. We were asking for gender justice, that men is also suffering. So at least they should get relief. And guidelines should be made by the Supreme Court when maintenance should be granted and how much maintenance should be granted, and when women should not get maintenance. Suppose woman is capable to earn, she was doing a job, but she left a job after marriage, or maybe she has not left. Even then, she filed a case. She changed the job and don't disclose. She changes the job and don't disclose at all. And then she started getting maintenance. Also, it's very difficult sometimes to even makes inquiries or to investigate whether she's working or not working. Nowadays, some people are also working from home. So, if in case she's working from home, even then she's getting maintenance. Very difficult to know. So, all these things are there. So these are the things when Supreme Court can grant, can interfere, but in this case, Supreme Court has not interfered. They said no, no, we will look into appropriate cases. Now, perhaps some more cases may come after some time. Perhaps Supreme Court may think no, it's now enough. Many such cases are even judgment are given by the High Court also, that no, if woman is working and she is capable to earn, then why should she should not share the burden of means child. She should also share the burden of child, and she should also maintain the child, or both the parents should have equal maintenance should be for the child. Like this, some judgments are coming, and even for the maintenance also, many High Court are saying why women are not able capable to earn herself. In one of the judgment, woman was asking a very huge maintenance. Court said, why this much maintenance? Maintenance is only to maintain yourself, not for your luxury. So these are the things, changes, I can say, coming. I hope that after some time, maybe some couple of years, or maybe I don't know how much time court will take to understand this aspect, that no, time has come, that it is necessary to give certain guidelines when women should get and for how long one should get maintenance. In nowhere in the world, woman keeps on getting maintenance. Nowhere. They only get maintenance for 2 years or some few years in case they want. No, I want for further time because children are small or something, some difficulties there. Then court extend it. But normally maintenance is not for lifelong. But in India, it looks as maintenance. It's not maintenance. It is a pension for a woman, which is she is getting from her husband. I'm sorry, I'm saying all this, but this is a factual thing which I feel no. This time has changed. Time has changed, and now women should also think about it. Law should not make them, useless by awarding maintenance. They should, if they are working and if they are capable to earn, they must earn.
Okay, ma'am, we have one question from Dinesh
Yes.
as well. How
Yes.
many PIL already have been filed and got judgment, and how many pending and still under process? How do I check PIL details whether PIL is filed or not?
You see, for about filing of the PIL, sometimes it is difficult to know. Suppose your subject is such, perhaps you may not get data, but it doesn't matter. The moment you will file a PIL and it is on the same subject, Supreme Court registry will link that subject matter because it will go in the PIL section. They will link it with the other PIL and they will inform the court one PIL has already been filed on this subject matter. So this is the court duty, they do it. But otherwise, one can check from Supreme Court website in case, but sometimes it's not practically possible to check up on the subject, on which subject, whether PIL has been filed or not. Sometimes you can come to know because in case there is a, some publication about the PIL issue, there is some news, maybe something, in some information you may get, but not necessary that you may get all the time.
We have one question from Dipali. Dipali, you can ask your question.
Yeah, good evening, ma'am. Dipali this side.
Yes.
Thank you so much for interesting session and the explanation that you have given. Thanks a lot for that. I have a little bit different question. Like we discussed, and I could gather from the session that we can raise a public interest litigation against a group of people. But then in today's era where AI is replacing humans, and there could be a lot of algorithms which are in picture, and there could not be in certain cases human beings not present there, and it would be algorithms. So with the changing trends, are there any new remedies coming up in public litigation or public interest litigation? That was my question.
You see, with the changing time, right now, it's not that there is any effective change. Uh, Although Supreme Court can develop such a device that they can have more information, they can know, and they can do cases also on the priority basis. But Supreme Court is not adopting any such method which may have effect on our pendency of cases or otherwise. I'm not aware of it in case they are doing it, but I'm not aware. I think Supreme Court should have their information about the cases, and they should have some method where cases which have priority as matrimonial cases, most important, because sometime people spend their whole life in matrimonial dispute. They in case one person file a divorce case, it may go on in the court, family court, for 4, 5, 6 years. Then it may go to high court, maybe for minimum 3, 4, 5 years, to maybe sometime 10 years also, then to Supreme Court. But no court is looking from this angle that such cases should be on the priority basis. So AI is there, but for this purpose, I don't think it is being used, or it can be used right now, because we can do it. We can have the knowledge management in court, but we have to work on it. We have to create such system or such app or where which can look into the cases, what type of cases are pending, what is the nature of the case, and whether they have a priority or not. Right now, there is no such system that we may take up such cases on priority basis, or we may take up the PIL on priority basis. No such system is there. It's all decision of the court. Court may give any date, or registry may give date through computer system. But so far, there is no such. I can say, as to my knowledge, there is no such system of using AI in this form, and it's not going to have larger effect as far as court is concerned, because for this purpose one has to train the AI also. Although one can have for the search system, it's very good. You can know the cases, you can search in better way. Earlier, we at my time when we started practice, we used to search in the books and digest. Then we used to take out the judgment and used to read. But now everything is available on the click, on the net, on the Google, or on the app, different app like SCC, online, Manupatra, etc. So all these systems are there, opportunities are there. But Supreme Court is not having any such system where we can say that there can be speedy judgment as speedy disposal of the cases through AI.
Thank you so much for the explanation, ma'am. Thank you. But my question was a little different. Even this explanation is very helpful.
Yeah, you can
But my
tell me
question,
what
but
exactly
my question,
no?
yeah, my question actually was, ma'am, how to quote it? Like in intellectual properties, okay, AI cannot be defined as an inventor. So any litigation against AI would be a little questionable, and there's no jurisprudence so far related to that, apart from there's something called doubles. Okay, so like that, if in future there stands somebody against some algorithm in the public interest, raising a public litigation, suit. So would it be possible? Is there any such kind of jurisprudence
You see,
in our system so far? That sort of question I wanted to frame. Probably I didn't frame it properly, ma'am.
yeah.
Sorry, but the information that you shared was also very helpful.
Okay, anyhow, I will tell you. You see, right now, this issue is still at premature stage. As you know, AI, whether something wrong information is given, then who will be responsible? Whether AI, how you can hold AI responsible, whether you can hold responsible to the creator of that particular AI system, or who will be responsible. So far, it's not clear. Uh, on this issue, there was a very good paper on Google. It may be they are written by Abhyuday Chandra, and it's very informative. If you want to know more, you can study that paper. It may be available on Google. But I may just tell you one thing. In US, there nowadays there are driverless vehicles also. Suppose there is an accident of such driverless vehicle, then who will be prosecuted for that? Suppose there is some mistake, and in case there is an accident right now, what we do? We file case against the owner, against the driver. But suppose AI is involved and vehicle is being run by driverless, method, then who will be prosecuted? Owner can say, "This is not my fault. I have created this, and it was going on its own way, and somehow a accident took place. So I'm not responsible. So why I should pay compensation then?" So these are the issues which are right now. I think it's premature. We have to yet study, and we will see how court will take up such issues and what will be the judgment in future. So just wait and watch. I hope something may come very soon.
Okay, we have one question from Divyendu. So, in the present time, the increasing use of PIL has contributed to judicialization of politics. So, how can the judiciary maintain a balance between ensuring justice through PILs?
Just repeat the question.
So, in the present time, the increasing use of PIL has contributed to judicialization of politics. So, how can the judiciary maintain a balance between ensuring justice through PILs?
You see, now in as far as our constitution is concerned, we are having doctrine of separation of powers. We are having different powers in through judiciary, through executive, and legislature. All the three wings of the state have different powers as given by the constitution, and normally they should not interfere in each other's domain. But what happens when one part is not functioning? Then other part has to look into it. Just for example, this is the job of the, you can say, legislature to frame law so people may get benefited. As in the case of Vishakha, there was no law for women who are being harassed at workplace. So judiciary has to intervene, and they pass certain guidelines. Subsequently, law was made. One thing. Another thing, sometime what happens, uh, politicians are, you can say, the government is not functioning properly. Suppose they are not functioning properly, or there is some deficiency in their working, certainly people may approach the court, and then court may pass the orders. As I will tell you, long back one case was filed that there has been many manholes which are open, and children sometimes fell in that manhole, and there is a death of innocent children and sometimes even adult also, especially in rainy season. Court, this petition I am aware it was filed in Delhi High Court maybe 20-25 years back. But court just dismisses. No, 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 no. This is not of our domain. We will not interfere. But now, after that, there have been various petitions filed in the court where court is looking into this aspect, not only this open manholes, they are also looking into various other issues. As there is a in rainy season, water is coming in the building, and then there has been death of 2 3 students, that issue was also taken by the court. So there are many such issues which court may say no, it's not our domain, but they are taking it into it. They are considering those issues under the article 32 or maybe 226, that yes, there is a human right is in danger, there is a violation of fundamental rights, so we can entertain such petitions. So they are taking up such petitions. This thing, another thing. Now, even legislature, sometime legislature, despite of the giving representation, not making law, and then people are approaching the court. I will just give you one example. One petition has been filed in the Supreme Court that's in our Hindu Marriage Act, there is a need of some changes, as Section 9, which is restitution of conjugal rights, is a meaningless because no court can pass any orders to any couple or any person. You go and live with other spouse, because this is not, you cannot force a person to live with someone. It's a violation of fundamental rights. Certainly, court cannot pass such orders. When court cannot pass, then why this Section 9, restitution of conjugal rights, is still in our books, statutes, in our act? It should be, amended, and it should be wiped out from the statutory books. Same way, there is a other provision, Hindu Marriage Act. It has been already having provision of divorce by mutual consent. Nowadays, so many people are approaching the court for divorce by mutual consent. Court can grant first motion, can grant pass order on first motion, then again they have to approach after 6 months, and in case there is urgency, they can also approach the court for waiver of this time also. What I should say, 6 months time also. And then court can pass this order.
Ma'am,
Yes, I will just complete this sentence. Sorry for interruption. Uh, Court can pass direction also that 6 months time is waived. And suppose court is passing this 6 months time, waiver of 6 months time. And nowadays I've seen in many cases people are filing application because they don't want to wait for 6 months long period. They said no, divorce case has been filed. We want divorce immediately, as soon as possible. So this is also has lived its life. 6 months time to approach the court again after 6 months has become useless, meaningless. So certainly now legislature should amend this law. And another thing, in everywhere in the world, if there are husband dispute between husband and wife, no court force them to live together. If they are not able to resolve their dispute, court will say, okay, you take divorce. We will give order for maintenance. We will give order for custody. We will look other aspects. But in case you are fighting, why court should waste its time just listening whether you are right or you are right? Means whether husband is right or whether wife is right. So they will not court will not waste their time. Mostly it is happening everywhere in the world. They don't listen all these things. But Indian courts is still listening, still having evidence on this, still having so many, wasting so much time on such issues. So I personally feel with that change of time, we should make changes in our legal system also. Court is also keep on changing, giving different view, taking different view, and they give pronouncement, which are not earlier. Now they change their mind and they give different view of the any prospect or any issue. So same way, time is changing. Same way, different people are getting different view, and we should also expect that court may have, may think about other issues which right now we think that there is no judgment from the court. So what court should do? I think nowadays time has come that we can approach the court for any grievances in case we feel that yes, there is a violation of fundamental right or there is a violation of other rights. And if in case we feel that yes, there should be change in our legal system, there should be changes in our legislature, and there should be changes in other aspects. So as far as judiciary is concerned, you must have seen recently there has been many cases in Supreme Court, and one very I will tell you another important case which I have just done some time before. You know, one person, one advocate filed a petition in the Supreme Court that there has been so much violation of system. Means there is this, in another way you can say, there has been complete deterioration of our electoral roll, and people are being removed from the voter list. There are many people who have been twice in the same city. There are many cities which are at different places, and in one house there has been many persons, even 100% having the same address, or some people are having zero address. All these issues are there. One petition was filed by one advocate of Supreme Court that there has been discrepancy, and this has been pointed out by one of the leader in Karnataka, and there has been, they have given data also in the, along with the petition. Data was given that these are the different cases where people are misusing this system, and election commission is not doing anything. They have not adopted any system. Now in the era of AI, they can have access to everything. In just by one click, duplicates names can be deleted. But no, nothing is being done. So all this plea was taken in that petition. And when this petition was filed in the Supreme Court said you go and approach election commission. Already person who is approaching the court has written to the election commission, but he has given no reply. Despite of this fact, also Supreme Court said no, you go and approach the you go and approach the election commission. So you can think that whether this was right step or not, I cannot comment, because this has come. Now court has already given the verdict. You go and approach the election commission, but it is best for you to judge what should have been done. So this is the way. So is this way, politics is also there, government is also there, and some fact on some facts court may look into it, as court has done that people have given donation to ruling party, and there also Supreme Court has given verdict that they should have disclosed the names of the person, and names were disclosed. Some names were such where people have, got benefit from the government. So these cases are there, cases are coming, and court is entertaining such cases.
Ma'am, I have a query regarding PIL. So,
Yes.
if there is a certain case in a court and it is almost already given judgment, the court has given its judgment and it is closed. After some years, can one again file the PIL after that case? Like I have to redo that case, like I have to again add a PIL on that case, even if the judgment is already given. Is it possible?
uh, I what I understand from your question, that issue has already been decided by the court. Okay.
Yes, ma'am.
Then somebody wants to change that verdict and whether person can approach for PIL. This is your question.
Yes, ma'am. Like, yes, ma'am.
Okay.
Yes,
Okay.
exactly.
Okay. So I will tell you one thing. Suppose judgment is in personam, that means judgment is for the particular person, then that particular person will be affected. No PIL will lie for that. But suppose there is a judgment for them, means judgment for everybody, and somebody or some persons or some class of people are affected, then certainly they can approach. In many cases, judgment has come, but thereafter people came to know that this judgment has come, then they approach the Supreme Court. As you can see, there is a vehicle pollution. Some order came from the court, but later on people approached the court. No, we were affected persons, and court should not be so harsh. Our vehicle is as new, as good as new. but we are being deprived to run it. So court started entertaining those cases. So it may happen sometime, but depends on a cause. If court may consider, there are many judgments which were passed, and later on, court, uh, after giving verdict, court realized no, there has been mistake on our part, on the part of court. Then they change the judgment. So it may happen even through filing PIL also, even otherwise also. I will just give you example of judgment of Antule. What happened? Court passed a judgment that this case will be heard by the High Court, which was pending in the trial court. You know, certainly we are having three-tier system. If a case is filed in the district court or trial court, then person will file its appeal on to before the higher court. It may come before the High Court, then it may come to Supreme Court. But suppose by order of the Supreme Court, court may give direction that you go, your case is transferred to High Court, and now your case will be looked into by the High Court. then High Court will deal with that case. Just a minute. If High Court will deal with that case, what will happen? Suppose judgment is not in favor of the person, aggrieved person, then what will happen? Person will go to Supreme Court, right? This is our system, that after the verdict of High Court, we will go to Supreme Court. In this case,
Yes, ma'am.
case is transferred to High Court. Just see that person's one right to file appeal before High Court is gone, right? If one right to file appeal before the High Court is gone by the verdict of the order, then certainly that order is wrong. So this way,
Yes, ma'am.
Supreme Court realized its mistake and they said no. This here we have by our order this mistake has been committed, and then they changed the verdict. Same way, Supreme Court has also developed another way of filing curative petition. What is curative petition? Suppose in any of the judgment, it is felt by an aggrieved person that this judgment is not correct, this is wrong, at the part of Supreme Court to not to consider these facts, certain facts, or maybe some other data. And then what will happen? That judgment will be final judgment. So naturally, no other court can do anything. But in Supreme Court, against the same judgment, if you file a review petition, that is also dismissed. Then what is the relief? You have relief. You can file a curative petition. And through that curative petition, one can approach the court. And in curative petition, of course, senior advocates' opinion has to go with that. That yes, I have read this case. There is some consideration point are there. Such issues are involved which this court should consider, and then that petition can be filed and court can hear the case again. So this is another provision in the Supreme Court, filing of curative petition, which I am just telling you. So this way, any petition can be filed.
Thank you, ma'am.
Any other question? I hope things will be clear to you as far as public interest litigation is concerned.
Yes, ma'am. I guess we can wrap up the session.
I will just tell you one thing. You know, in public interest litigation and other litigation, what is the main difference? Main difference is this, that suppose a person is having some grievances, then one can approach for remedy, for personal injury. One can file a case. But in case injury is not of personal nature, but he feels, any person feels, or any organization feels, public at large is going to be affected, then they can file a public interest litigation. And public interest litigation can be filed just for that cause of where larger public is going to be affected, not any personal thing. So that is the main difference between public interest and personal interest litigation.
Ma'am, we have one question of Winnie.
Yes.
Now, students do have many issues in universities or colleges. So can a student file a PIL if they find absence of promised conducive academic atmosphere as outlined in the prospectus and the apparent reluctance of the authorities to uphold the pledged standard of education?
Yes, it can be filed, but I will tell you, nowadays court is very careful about issuing of such notice on such petitions. They call that this is a personal publicity cause. This is not PIL. This is, you can say, personal interest litigation. So it should not look that it is a personal interest litigation. I will just give you one example. Suppose there is some time in some colleges there is a ragging, despite of the fact that it has been stopped by the Supreme Court. There are various judgments and colleges are also taking a step, but still it is going on in some college. Certainly, one can write to the Supreme Court. One can file a petition in Supreme Court that this is still going on in this institution and can prove. But there are certain conditions. One should approach the authorities, one should write to the principal, one should take necessary steps to approach different authorities who are concerned to look into such aspect. Then still if nothing has been done, then one can file a public interest litigation, not only for this, for any other cause also, for, which is there in the college or maybe in the university or any institution. It can be filed, but it should not be of one person. It may be, general cause. As I told you in Sunil Batra case, what happened? Person was in Tihar jail. He filed a public interest litigation, wrote a letter to Supreme Court. But that letter was treated as public interest litigation. And what he has done, he has written in that letter what treatment is being given to other fellow prisoners. He has not written about himself. So, in case cause is such, then certainly it should be, public interest litigation can be filed. Yes. Any other question? I was just looking. Some question came here but disappeared.
Ma'am, there's a question from Dinesh.
Yes.
Did any PIL filed against the wine bar shop? As we all know that such things harm the people a lot, but still they are growing a lot. No one opposes the same. Please share your input.
Against the wine shops,
Yes.
liquor shops. Yes. You see, against liquor shop, there is no such PIL as per my knowledge. But I remember there was bar dancers in Bombay. They used to serve the liquor, and then there was a ban on that bar dancers. Ban was this, that you cannot dance in the bar and you cannot serve liquor. Then many people approached Supreme Court, and then Supreme Court gave verdict. And Supreme Court gave verdict that Supreme Court said, no, you cannot deny bar dancers like this. There is a question of their livelihood, so you cannot do it. So this is the way. As per my knowledge, no such petition is there. But this about bar dancer, there was a petition. I think it's enough for the day. If you have any other question, you are most welcome anytime.
Yes, ma'am. I guess we are done with the questions. We can wrap up with the session. Thanks a lot, ma'am, for taking this session. It was a really insightful session. Everyone learned a lot, and we are super grateful to you for being a part of this webinar. And thanks a lot, ma'am.
Thank you, everybody.
Thank you, everyone, for joining this session. And yeah, we will meet next Saturday. See you guys. Bye.
Thank you.